they claim they didn't know about. And lawyers and judges do not care whether you know. But on the flip side, there is a moral duty for lawmakers to ensure that the citizenry is aware of the laws they make. There's a moral duty. But now the question is, when public hearings are called before bills are passed, how many of the citizens attend? So the lawmakers would say, we called for a public hearing, we advertised it, we played it on Zoom, we sent out notices, we made sure that we used technology to make sure that many people can hear. But at the end, we went to Zoom, less than 50 people. We went on Facebook, less than 300 people. We owe the country a duty to pass the law. And they have the moral justification to pass the law. But incidentally, that law that less than 2,000 people contributed to, when operational, will affect 200 million people equally. That is why the docility of the citizens has been the problem of democracy in Nigeria. When you talk about leadership and followership, I hold a strange and unpopular opinion that the problem of our country, and any country whatsoever, is not leadership, that the problem of our country is followership. How do I say so? Leadership is a microcosm selected from followership by followership. There is no place where imposition is possible without acquiescence or cooperation. Coercion occurs with some degree of acquiescence. So, for example, the selection of a candidate of a political party, the entire structure of the political party is made of followers, in a sense. So how do you now blame one person who is the leader for over 3,900 people who will take a decision? So it's followership that's the problem, it's not leadership. The day the followers insist that enough is enough, enough will be enough. So this seminar, this workshop today, is to alert people that whilst passing a very beautiful national enactment to stem the ugly tide of cyber crimes that has given Nigeria a very bad image globally, that there is a section of it that may affect you that you may not be aware. And the choice of the keynote speaker is strategic, because I've looked at the several times that people have been arrested, whether journalists or blogger or conversationalist, any name that you put, most times he has been the defense lawyer. So we decided to make the hunter the hunted. So clearly he owes a duty to prepare your mind so that you do not fall into the temptation. But now the flip side of that is that he's going to lose some clients, because he makes money by you falling prey of this law and him coming to defend you. But the truth is, as we get close to elections, I know that different impulses will arise. People will be stimulated more to cross some lines. As Commissioner for Information, yes, I owe a duty to try the best within the powers embedded in my office to keep the information circle sane for everyone, including the opposition. The Commissioner for Information is not just the governor's mouthpiece, is not just the government's mouthpiece, is the mouthpiece of the states. His duty, like that of the Attorney General, transcends the protection of his boss and the government he serves. It includes protection of the image of the entire state and the projection of same. Therefore, even the opposition must be protected by both the Ministry of Justice and the Ministry of Information. And therefore, this seminar, this workshop, this talk shop is for us to gather together as people who may be affected by this legislation. People who, in the process of expressing our opinion, we may run foul of the law. let's bring the legal implications of these laws to the fore so that we can begin to guard and guide ourselves. Because like the Bible people say, people have already fallen foul of this law and are already paying the price. And immediately you run foul of it, and the person who is at the receiving end decides to activate the law. There is no place for sympathy. No matter what the NUJ does, free Igbabida, according to Marcos, free Ekba, free who? It's only an appeal. And if that appeal falls on deaf ears, you go in for it. So dear friends, which is why we made sure that away from this fiscal audience, that we have also mobilized every social media platform and it's running there. The idea is that people can join us live, others who are unable to join us live can join later, can have the privilege of going back to watch and hear, so that when the law is activated, and it's not just against government, it's not just against those in government. Even private individuals can activate the law. Finally, dear friends, great panelists have been selected. Clay Tusukbong, Clifford Thomas Esquire, Enwan Klopas Acquire Esquire, Nsika Idiong, PhD, McDonald Diko. Across the spectrum, the idea is that before you start calling McDonald frantically, let him tell you what the police expects of him. Because he wears that uniform on trust, holding the trust of the Inspector General of Police at the first instance and the Commissioner of Police at the second instance. And when he is given instructions, he will activate it, irrespective of the friendship status between both of you. So today he would have the opportunity to bring the police angle to some of these issues. Because in some of these things like defamation, there are two ways to approach it. So if people decide to go through the police, you don't decide, when you create an infraction, you don't decide how the person who is injured should go about seeking his redress. You can't determine it. So if the person decides to go civil, it's his choice. Decides to go through the criminal aspect, it's his choice. So today we have brought a cross spectrum of people. Clifford will come with both the law and media practice, which he's been well versed, the former chairman of the Correspondence Chapel. Enwong will come from, Enwong is an online guru, an influencer, a conversationalist, but she's also a lawyer. She's also been into advocacy that has thrived majorly on social media. So she would also come from that perspective, and she's a young person. Clifford will come with age, experience on both the law and journalism. McDonald will come from the enforcement part of it. And when you go to Clay Tusukbong has done a lot of investigative reportage and journalism, and we've not seen anyone take him to court, or if they've taken him, we've not seen people win against him. So he should be able to also share with us the tricks he has been using to navigate through the water. Then Sikak will come with the intellectual disposition to these things. What should be, as different from what is. Away from that, we have people from critical sector who would give goodwill messages. The NUJ chairman is here, the NIPR, the KUPA, the FUMPRA, and the Nigerian Bar Association. Dear friends, this is a very important event. Ekemini Udome Squad told me that he will not take too much of our time, but he will elucidate. He sent a paper in, which I'm sure would send to your email addresses. So as you immediately after, we won't send now so that you won't be struggling with reading while he's presenting. Listen to him first. Immediately after he finishes his paper, he will hit your email addresses directly so that you can go sit down, highlight those issues, have that copy for yourself. But there are two parts of technology that I would just like to drop for us, that we use that to think while we would invite a Ekemini. Technology has come to stay. And there is absolutely nothing you do about it. There are two parts of technology, the disruptive technology and the accumulative technology. It's either accumulative or incremental. So, disruptive technology is technology that comes and changes the entire pattern of our lives. For example, GSM. the fact that GSM came disrupted our lives completely. Because ordinarily, I would have to visit Nsemeke, but GSM means that I have to call him. Before, GSM was a precursor of the landline, but the landline was as effective as the person knowing where the person is to call. Which is why if a side chick needed to call, the side chick needed to time when Oga was in the house to call. Because by the time you call, it could be Madam seated by the phone, and there will be crisis in the house. But mobile technology, mobile telephony, made it that you could reach someone anywhere and everywhere. It disrupted the way we lived. It meant that Nsemeke could be in his house and tell me he's in Lagos. Clear disruption. But now when you look at the use of SMS and other things, those are not disruptive. It's incremental. It's only running on an existing technology and making it better. I read Harvard Business Review, the latest edition, and the question they asked is, what next for technology? When I finished, I asked myself, do I still want to be alive? The truth is, as Christians, I'm sure you've been taught of 666, 777, 999. You've been taught, Abi? Prepare your mind, those of you who want to live very long. The future of technology is a chip embedded in the body. It may take time, but it's going to happen. It's going to happen. So, this disruptive technology, because man wants the easiest way out to things. So, your ATM card, you don't want to have an ATM card that someone can take it from you and swipe money and remove from your account. So, all you do is that you get to an ATM account, you simply put your fingerprint, and you do the deduction, you withdraw your money. It means that you enter a place, for example, this seminar, immediately you are registered online, we'll key into that your unique number. As you come, we just know you are here. We are getting there. As scary as that looks, but man, we need to brace up. So, for the lawyers, like Ekebinudum posited in his paper, which he gave me the privilege of advanced reading, that when the criminal legislations of our country was enacted, the cyber part, the computer usage, and the use of computer for mass communication. When Prof spoke about use of computer first came used in the oil and gas sector, later used for academic purposes. It was restricted. But today, the computer has become a tool for mass communication. So now, the National Assembly had to react immediately to it. And anything you react to, you are likely to make mistakes because at the point of reaction, you may not have all the facts together. So we need to, as lawyers, as journalists, and I don't know how many journalists contributed to the making of that enactment. So we need to, as journalists, as lawyers, as citizens who are concerned, begin to think futuristically. So that the day you hear the Akwa Ibom House of Assembly wants to make a law that will affect technology, you are already armed to know whether you want the chip in your body or you want another form of technology. Because the truth is, if we live long enough, you may either have a chip or you may choose to remain disadvantaged in the world of that time. My duty was to just set the tone, state the reason for bringing you out of your holidays. I think I've done that. It is not my duty to speak to the paper. The duty it is of a gentleman who is a senior partner of Justice Chambers, the gentleman who led the legal team that saved the state and the House of Assembly when the House was on fire, a gentleman who has saved a lot of journalists, a lot of conversationalists and bloggers, taken them out from jail, from the doors of jail. He has prevented many from going to jail, and he has taken many out of jail. A lawyer, an author of many respect in the legal field, forget his size, like Prof said, forget his name, like Prof said. Gentleman who has a lot upstairs to offer. Humble, affable, soft-spoken. One whom we are sure will be a senior advocate of Nigeria. Help welcome to deliver The keynote lecture on the topic cyber crimes and other press-related infractions, the legal implications, Ekemini Udom Esquire. Please, a round of applause for him. That's not how you clap for your lecturer. Or let me do as he does in court. My lord, Ekemini Udim. So one judge now say, is it Udom? He said, no, my lord, I am of Anang extraction. Ekemini Udim. U-D-I-M, my lord. Please help welcome, appearing, Ekemini Udim.
The Honorable Commissioner here present with us. When I spoke with him this morning, I never knew he would be with us today in Uyo. Thank you for coming. The chairman of today's occasion, Professor Esu. In my days in the university, I remember Professor Esu coming to the Faculty of Law to teach us a lot of things. Most of the things that Professor taught us then, we are still making use of them today. Prof, I can't thank you enough. I'm glad to see you here today. The Permanent Secretary of the Ministry of Information, the directors of that ministry, the chairman of NUJ Akwa Ibom, members of the High Table, distinguished ladies and gentlemen, it gives me so much pleasure to be here today. The commissioner likes reminding me of a lot of things. The last thing he said, we were together in court at Barenin, and that happened between me and the judge. I thought the commissioner had forgotten that. But he has a special way of keeping vital things for conversations. I'm so glad to be here today. My job is just to highlight the legal implications of cyber crimes and other related infractions. And I have a paper. I've given instruction for the paper to be shared. I also have the the soft version of it. Because the paper is in your hand, I'm not going to take much time. I will only highlight, because I know that you will have time to digest my thoughts on this. So if I don't take much time, please pardon me. Cybercrimes and other press-related infractions, the legal implications, being the text of a paper presented by Barrister Keminudim as keynote speaker at a symposium organized for journalists and bloggers by the Ministry of Information and Strategy, Akwa Ibom State. Preamble. It gives me great pleasure to be invited to address this gathering as a keynote speaker on this highly important subject. When the invitation was extended to me, I accepted it without hesitation. It was Edmund Burke who, during a parliamentary debate in the House of Commons in the Great Britain, that described the press as the fourth estate of the realm. He did not give this description for the fun of it, but he did so in recognition of the crucial role played by journalists in maintaining balance in society and in the process keeping society constantly informed. Journalists are the watchdogs and sentinels of society. And one can only imagine how society would have been without journalists. The journalist educates and also entertains. The person who educates and entertains others must himself be fully armed, not only with the fine principles of journalism, but also with the applicable principles and provisions of the law. Here lies the importance of this gathering, which is aimed at highlighting critical issues of law for the benefit of the journalist, to assist the journalist, going about the legitimate work without, his legitimate work without falling on the wrong side of the law. A few definitions would suffice. Cybercrime simply means the use of computer as an instrument to further an unlawful end. Now, there is another definition of cybercrime, which is an illegal activity that is carried out with the use of the internet. Follow me at the foot of that paper. The common denominator in most definitions of cybercrime is the making of reference to the internet and computer. We all know the computer and the internet are like inseparable twins in today's world. By the Evidence Act, which is applicable in Nigeria today, the phone is also defined as a computer. And so it's not only the big screen in front of the turbo, the phone that you hold by the Evidence Act, applicable in Nigeria today, is also defined as a computer. Now, back to the topic. Let us return to the topic of today's discussion. Cybercrimes and other related offenses, cybercrimes and other press-related infractions, the legal implications. Gentlemen, ladies and gentlemen, this takes us directly to the Cybercrimes Prohibition, Prevention, etc. Act, Laws of the Federation of Nigeria, 2015. Professor Isu did say that Nigeria waited for a long time before our having the first cybercrime law, and that's true. I personally, I was surprised that we had to wait up to 2015 before having a law like this, whereas so many infractions had taken place over the years. But it's better late than never. This is an act of the National Assembly of Nigeria. It was passed into law by both chambers of the National Assembly. In compliance with lawmaking procedure, the bill was assented into law on May 15, 2015 by the President and Commander-in-Chief of the Armed Forces at the time, Goodluck Ebele Jonathan. The preamble to this act describes the act as, quote, an act to provide for the prohibition, detection, response, investigation, and prosecution of cybercrimes in Nigeria and for related offenses. This one makes me remember Odika McDonald. I'm sorry I didn't mention his name at the commencement of this. A gentleman par excellence who is very active with what he does for the Nigerian police. Thank you very much for what you do, sir. Ladies and gentlemen, the preamble I just read does not in any way suggest that the work of the journalists will be affected by the provisions of this act. You know, this act was passed in such a way that a lot of journalists were taken by surprise. It was not anti-press freedom law, so a lot of people slept. They never knew that in the belly of this law, something is going to be provided to address what you do as journalists. The preamble is harmless, and the journalist may be tempted to look away from the law and not bother to peruse its contents. This, ladies and gentlemen, will be a dangerous decision to take. The reality is that the Cybercrimes Act, Laws of the Federation of Nigeria, has in its belly provisions which every media practitioner must be mindful of. I shall highlight these sections in this paper in no particular order. Now, I go straight to section 24 of the Act. That is the section that if a journalist is to be taken to the court, that's the section that is mostly activated against the journalist. So you see the charge. The charge sheet will read that so-so person has infracted so-so, and this section of the law is going to be quoted. So let me read it out so that we can have this conversation together. This section provides, unquote, any person who knowingly or intentionally sends a message, underline, a message or other matter by means of computer systems or network that he knows to be false for the purpose of causing annoyance, underline, inconvenience, underline, danger, obstruction, insult, injury, criminal intimidation, underline, enmity, hatred, ill will, or needless anxiety to another, or causes such message to be sent, commits an offense, listen, under this act, and shall be liable on conviction to a fine of not more than 7 million naira. I mentioned the amount, 7 million naira. Or imprisonment for a term of not more than 3 years, or to both fine and imprisonment. Ladies and gentlemen, if you followed me very well while reading that section, you will understand that there is trouble on the land, in the land. You will understand that it is no more business as usual. Perhaps you never knew this. And that is why when I have the invitation to defend a journalist in court, and I see that this section is a section used, I'm always afraid as a lawyer. Why? Because if you make any mistake, this provision is couched in such a way that you need to be very tactical in your defense. If you are not, the journalist will go to jail. And you may not be lucky to have a judge who has this option of fine to give you. So the judge may give you the two punishments in the section. I would say you go for the year's imprisonment and also pay 7 million naira. After all, he never knew how the judge was defamed by somebody on social media. And so there are two schools of law that I believe in. There are many schools, but I believe in two. The positive school, which says that law is what the political superior would say, backed by sanction. And in Nigeria, you see that National Assembly makes a law, and there is sanction in the law. There is another school of law that says that, and that's the realist school of law. It says that law is the prophecy of what the courts will say and do, and nothing more pretentious. Lawyers in the hall will remember these and agree with me. Now, that last definition of law, which is from the realist school, is for me very true. The judge can decide a matter based on the experience of the judge, and then uses the provision of the law to nail the person that is standing before him. But he's expected to do so legally and judiciously. So this section of the law is something that journalists, bloggers, and every category that Professor Isu did give, should be very mindful of. When you go online, be mindful of what you are publishing. I proceed. In my paper, I have said some words and phrases naturally stand out from this provision. They include grossly offensive, for the purpose of causing annoyance, obstruction, insult, injury, enmity, inconvenience, ill will, and needless anxiety to another. These words and phrases are capable of more than one interpretation. This is where the journalist must be deeply concerned and worried. In most cases, the words are subjective and can thus be interpreted differently or variously based on the standpoint of the individual. When words are capable of causing confusion or posing challenges of interpretation, what the lawmaker usually does is to include the interpretation section to the law. But surprisingly, in the interpretation section of this law, which is section 58, there is no definition of these scary words. So, the legislature has left it to the discretion of the judge and has also left it to the discretion of the police and to the discretion of the DSS. Now, before your matter goes to court, you would have first been arrested, profiled by Odiko McDon and his men, and further profiled maybe by the DSS, and then possibly detained for some hours. You would have suffered a little before your matter eventually gets to court. And that is where the journalist needs to be careful, because these words are subjective. But when you look at them naturally, you see, you as journalists, you will know the kind of publication that is unacceptable, the kind of publication that is certainly going to run you into trouble. I flip over to page 3. It must be stated in paragraph 2 of that page that section 24 of the Cybercrimes Act is the first of its kind in the history of lawmaking in Nigeria. And being a law of the National Assembly, its applicability is nationwide. And so wherever you stand to make a defamatory publication against someone, you can rightly be arrested and prosecuted. Thus, the writer of an article for a publishing house, the editor, who must have edited and authorized the publication, and the publishing house as a corporate entity, can each be made liable for an online publication adjudged to be insulting, inconveniencing, grossly offensive, annoying, obstructing, motivated by ill will, injurious to character, and vexatious, contrary to section 24 of the Cybercrimes Act. Ladies and gentlemen, you will agree with me that anything, even the truth, can annoy a typical Nigerian politician, depending on his mood at the time of the publication. But in spite of this, what the law requires of you is that you should do the right thing. I'll get to the point where I'm going to tell you that the law has a defense for you as journalists. And truth is a complete defense in law. And so even when your publication is vexatious, even when publication is annoying, even when your publication is insulting, what you should tell yourself is the fact that your publication is telling the truth. When you tell the truth, you are covered by the law. But we'll get to that. Now, expectedly, the coming into force of section 24 of this act has elicited mixed reactions from several quarters since 2015 till date. And several journalists have been arrested, detained, taken to court, pursuant to this law. I've defended a couple of journalists, so I know that this section of the law has also been activated against journalists and also against bloggers. I have also been on the other side where I have to write a petition for clients to the police to investigate someone who wrote something defamatory on social media against my clients. You will remember in the wake of COVID, when people like Def Pen was arrested for saying that some very important persons in the States were having an affair with some married women in a particular hotel in this town. I report to you that I am the lawyer that wrote the petition, for that person and for his group to be investigated by the police. They were arrested, investigated, and they could not provide any defense. I was waiting for a defense to tell my clients, these people have a defense. Can you kill this matter at this point? But they never had any defense, and the matter went to court. So I have been on two sides. I have had occasion to petition, and it is my duty as a lawyer. I've also had occasion to defend those that have been arrested and prosecuted. Now, Jonathan Rosen, a senior researcher, African program at the Committee to Protect Journalists, CPJ, recently called on online publishers in Nigeria to rise against the Cybercrimes Act of Nigeria, while observing that Section 24 of the Act is frequently being used to gag the Nigerian press, leading to the arrest of many journalists by security agents while denying them access to their lawyers and families. I got that from Premium Times of October 16, 2020, with the title, Reject Cybercrime, CPJ tells Nigerian online news organizations. Without press freedom, recent studies have also shown that cybercrime legislation is posing a threat to press freedom. I personally don't call it a threat. I call it something else. I'm thinking that what it has reduced is not press freedom. It has reduced, for me, those that had no business with your noble profession. And so it has sent them back. They've receded to go and think of how best to convey their messages. Without press freedom, the world is at the precipice of returning to the dark days of old, when human rights and freedoms were disregarded at will, at the whims and caprices of the leaders. A lot of journalists have been arrested as a result of this law, and that shows you clearly that the law is in full operation. You see, Abba Jalingo was arrested for defamatory article against Governor Ben Ayade. I've also stated at page 3 that in August 8, 2015, a blogger by name Abubakar Sadiq Usman was also arrested. In 2015 September, Emmanuel Ojo was forced into exile following threats to his life after he published a story about money laundering involving the then First Lady of Ogun State. In October 2015, Desmond Ikachima, a blogger, was also arrested. Sheon Oloketui was also arrested, a blogger. Chris Nwandu was also arrested. He's also a blogger, the president of the Guild of Professional Bloggers of Nigeria. Musa Bale Azare was also arrested. Kemi Olonoyo was also arrested. If you know Kemi Olonoyo, you will not be surprised that Kemi was also arrested. You know, but surprisingly, Kemi is a professional journalist, well-trained, in the best of schools. A lot of other people. Uturofon Morgan here was also arrested, taken to the Federal High Court. I appeared for him as lawyer, and thankfully, the charge was dropped against him. There's a Soundcraft that has just been arrested in Akwa Ibom for making a publication considered to be offensive to the person of the governor of Akwa Ibom. For those of you that are trained journalists here, when you take the publication, I'm not prejudicing him, I'm not saying he's guilty. But when you take the publication of that gentleman and give it an analysis, you will tell yourself the truth, whether that was part of journalism or not. You tell yourself the truth about that. But I wish him well. I am not prejudicing him. Distinguished ladies and gentlemen, one of the things that stand out in the above examples of persons that have been arrested is the fact that Section 24 of the Cybercrimes Act is not only available for activation by persons in government, but also available to private citizens who can equally make complaints to the police or DSS for investigation and prosecution of anybody who writes falsehood against anyone on the internet. This therefore calls for caution, the use of the cyberspace by everybody. So, for some time now, we only see most times government functionaries activate the law. The law is such that anybody can activate it. I can activate it. If you write something against me and I find it very offensive, I find it annoying in the language of the law. And the police will investigate the matter in spite of the fact that I am not even near to government house. Now, is the law entirely bad? Because a lot of people have criticized this law. A lot of people. I just mentioned Jonathan Rosen, who spoke with Premium Times, and then criticized the law very vehemently. But is the law entirely bad? While in most quarters the law is seen as an attempt to cage or gag the press and unduly intimidate journalists and bloggers from playing their sacred role to society. It is viewed differently by other persons in other quarters. Thus, a man against whom a fabricated story was published by an internet user, which publication has caused him serious embarrassment and reputational damage, will surely hail the lawmakers for the inclusion of Section 24 in the Cybercrimes Act. It is wickedness and clearly inhuman for a person to hide behind his computer and fabricate false and non-existing stories against a fellow human. No journalist, no blogger worth his name and integrity should engage in such ignoble practice. It is wrong, it is unconscionable, it is despicable, it is cowardice. It should never be contemplated, let alone carried out by anyone. From most fabricated stories, ladies and gentlemen, families have crumbled, business opportunities have been lost, people have been stigmatized in society, jobs and appointed positions have been lost, and sometimes lost forever. People have gone into depression, others have died. Fake news is indeed a serious menace to society. The purveyors of this brand of journalism, in quotes, are the emergency journalists or the accidental journalists, most of whom do not have the patience to go through the formal or even semi-formal training in the fine arts of journalism, which detests fabrication of news and defamation of character of persons. These are the ones that give a bad name to the glorious pen profession. These are defamers without borders. They can pick on anyone and everybody. Their newsroom operates non-stop and does not go on vacation or holidays. They pick their targets randomly. The non-politician is not spared, so also is a politician. Some of you seated here, the professional journalists who have spent so much time to go through school, to also be trained on your job, you have also been victims of these defamers. In all this, society suffers the brunt, while the emergency journalist disappears to thin air. This brand of journalism came with the wave of the internet and was not available at the time of the enactment of the Criminal Code. Criminal Code is applicable in the southern parts of Nigeria, and the Penal Code is applicable in the northern parts of Nigeria. Thus, something needed to be done to check the menace of fake news and deliberate defamation of persons' character on the internet. This perhaps is where the idea of the cybercrime law was conceived by the National Assembly of Nigeria. Ladies and gentlemen, a law which seeks to prevent mischief makers from doing damage to families and doing damage to society at large will find support in the court of law if such law is presented for judicial scrutiny and interpretation. The law is interested and deeply concerned about societal cohesion and will not allow a handful of people to wreak havoc to society. Laws in most cases are made to check mischief in society. Thus, since every decent person in society is now at the danger or risk of being defamed through the internet under the guise of freedom of expression, a law which sets out to curb this menace, such as the Cybercrimes Act, if properly directed as mischief makers, carriers of fake news, and destroyers of societal fabrics, will also receive the approval of courts. After all, the real journalists are not the ones who carry fake news. Am I correct? Yes, the real journalists are not the ones who carry fake news, because you have a name to protect. You work in a media house that has integrity. So, when Cletus Ukbong publishes something that is false, well that he's dragging the name of that establishment to the mud. When someone working in NTA carries the news item that he's not sure of, he knows that he is dragging the name of that institution to the mud. Ministry of Justice, University of Uyo, any other decent place. So, you're always mindful of your name and where you're going, the people you represent. So, I am correct to say that real journalists are not the ones who carry fake news. The real journalists are the ones who report stories based on facts, based on thorough investigation, and based on truth, devoid of fabrications. I'm always afraid of the publication of this gentleman called, the gentleman I just mentioned his name from Premium Times, Cletus Ukbong. He digs it to the end of it. And when it comes out, it's difficult for you to take him to court. The Honorable Commissioner did say that he hasn't been taken to court before for reporting falsehood. And that's correct. And he's going to tell us how he does this in his organization. Because I feel that there are layers checkmating falsehood from going into the media space, you know. And for some of us, when you want to know what's happening, you first visit some media houses, some websites. Once you have it there, you know it's true. But if you have the same information in some other places, you still want to know, you still want to investigate. And I think that's what journalism should represent. For the professional journalist, fabrication of stories is an anathema. While I agree with many that some provisions of the Cybercrimes Act are a bit nebulous and capable of affecting several persons, I also posit that something needed to be done to insulate society from the audacious wave of fake news and mindless defamation of people's character. Gentlemen, it was too rampant, and the legislature could not have been rightly expected to shy away from the reality. Fake accounts were created for the sole purpose of maligning people. The worst periods were the political seasons, when perceived opponents of some persons needed to bring down, needed to be brought down by all means. No decent society, journalist, could have folded its arms in the midst of such menacing wave that was destroying society. But what do you do at this point as journalists and as bloggers? In legal circles, there is what is called the law as it is and the law as it ought to be. One deals with the present state of the law, and the other is aspiration for the future. You say, okay, we need amendment of this law. Okay, the presidency, for instance, wants section 84 sub 12 of the Electoral Act to be expunged by the National Assembly. That is aspiration for the future. That is the law as it ought to be according to the presidency. But the law as it is today is the fact that there is section 84 of the Electoral Act sub 12, which precludes political office holders from participating in some of the political activities. So that shows you the difference between the law as it is and the law as it ought to be. The law as it is today, by section 24 of the Cybercrimes Act, is that as a journalist, you have to be careful. Before you go and make advocacy in court and ask that this section be changed, or be amended, or be thrown out, and so on, the law is still taking effect, taking a toll on those that have disobeyed the law. And so my advice is, play by the rules. I have gone through the rules of the journalism profession, and I have seen, maybe I'm right, maybe I'm wrong, but I think that if the fine principles of journalism are obeyed by every journalist and by every blogger, nobody will run into trouble. No journalist will run into trouble, because journalism will never teach you to carry fake news. Professor Isu will never teach you in the class to carry fake news. Des Wilson and the doctor seated there, I am sure they will never teach you in class to carry fake news. Journalists have played key roles in society and have risen to preeminence and have clinched elective offices in several states of the Federation. Olusegun Oshoba was the man who first discovered that an abandoned corpse that was just by the roadside in the outskirts of Lagos was the corpse of the first Prime Minister of Nigeria, Sir Abubakar Tafawa. He discovered that corpse 6 days after the first military coup of January 1966. People were passing, they didn't know it was Tafawa Balewa. But as an investigative journalist, he saw the corpse, got closer, looked at him, checked a few newspapers, and said, this is the corpse of Tafawa Balewa. Now, that same person, he worked as a journalist with Daily Times at that moment. He distinguished himself and eventually got elected as a two-term governor of Ogun State. Smart Adeyemi is in the National Assembly today because journalism showcased him to the world. I remember when Smart was the president of the Nigerian Union of Journalists. He was very active. Journalism exposed him. The deputy governor of Akwa Ibom State, Moses Ekpo, came to limelight through journalism. He was this and that when you look at his profile. And in all this, he was a journalist. He still remains a journalist. So journalism has the propensity of exposing you, all of you seated here. But it will be bad news if after being exposed, you're almost having the opportunity of occupying a public office, and someone brings it out that you had been convicted by a court of law for defamation of the character of anybody. True journalism must be anchored on truth and accuracy. It must have the attributes of independence, fairness, and impartiality, accountability, and humanity. So when you say that a married man is having an affair with someone in a particular hotel, as was reported in Akwa Ibom sometime during the COVID, and you know very well that that is not true, what are you doing? You are destroying somebody's home. You are not thinking humanity in your report. Now, there are other sections of the Cybercrimes Act which also you should know. Section 23 of the Act. This section prohibits the publication of child pornography on the internet or any social media space. Now, unfortunately, we have seen despicable things recently in some parts of a particular state in the western part of Nigeria, where children 8, 9, 10 or thereabouts are engaged in what has shocked a lot of people. I tried to watch it and my phone almost fell down. I said, these children at this age that are doing this, they were in trouble. But the cybercrime law also seeks to protect the identity of these children. The cybercrime law understands the fact that these are children in trouble, perhaps poor parentage, and that they don't know what they are doing to a very large extent. In fact, in law, if you charge a child of 8, 9, 10 to court, you are wasting your time. Because in criminal law, these children do not have the capacity to commit crime. And therefore, even when a child of 8, 9, 10 takes kitchen knife and unfortunately stabs and kills, that child is not tried for murder because he doesn't have the capacity in law to commit that offense. And that is why society is interested in the welfare of children. When I was growing up, upbringing of children, raising children was a community thing. Professor Su has said that he doesn't like importing things from America to just plant them here. In America, it's a very free world. But in Africa, the raising of children is a community effort. I go to the stream and someone finds my trouble and then I keep my basin aside and then we start fighting. Someone that is not my father, someone that doesn't relate with me at all, but is from that village, as he's passing, he stops and then tells me to walk away from that place. That's the beauty of the African continent, where the raising of children is seen as community effort. And so, for the sake of these children, the cybercrimes law prohibits the publication of pornography, child pornography, and therefore you saw that when that thing happened, Lagos State government immediately made a publication that anybody that circulates that video will go to jail. Now, the consequence of that is a fine of not more than 20 million naira or 10 years imprisonment or both. You can find it in page 7 of my paper. Prof did say that in Nigeria, it's either you're given an option of fine or very light sentence. Prof is correct. But this law is not like that. This law ensures that you pay and you feel it. I mean, 20 million naira, even as the country is so terrible now economically, 20 million naira is still a huge sum. Can buy you a plot of land in Shelter Africa. And then, if you stay in prison for 10 years, and you are married to a new wife, by the time you come back, your wife would have either so let me not say it. So 10 years is a long time. That's the message there. Now, in section 25 of the same law, there is now the tendency for some bloggers to make use of a name registered by another person. Such bloggers use the registered name to commit infractions and disappear. If you check Facebook now, you see some adverts said to be by BBC Pidgin, and they're advertising porn. They are advertising crypto. No, not crypto. This one that a lot of people have lost money. Ponzi scheme. And you ask yourself, BBC, as a standard organization, does not even take adverts. Listen to BBC 24 hours a day. You're not going to hear any advert. So how much more BBC will now go and be advertising a Ponzi scheme on Facebook? So some Nigerians have done this. There is a law against anybody who does that. Use your name. If you are doing something legitimate, go and register that name. Use it. Be proud of it. Hold on to it. Do not use another person's name. If you do that, the consequence, because you're talking about legal implications here. So the legal implication is to 2 years imprisonment or a fine of 5 million naira or both fine and imprisonment. So what some people just take it for granted. They'll say, nothing will happen. There is a consequence waiting. It's just that this consequence has not yet been activated by the police. And I'm charging Odiko McDonald now, with due respect, that the law has given a responsibility to the police. When some of these petitions come, please activate them so that people can learn before society collapses as a result. In section 26, this section prohibits the publication and distribution of racist, xenophobic materials to the public. The internet is a public space. The legal consequence is 5 years imprisonment or fine of 10 million naira or both. I like the makers of this law. They give punishment and then heavy sums of money. The journalist and the blogger should please take note of this. You saw what happened in South Africa, where because of xenophobic attacks and so on, a lot of Nigerian citizens were killed, a lot of shops were burnt and so on. Now, the cybercrimes law has criminalized the publication of xenophobic materials. I'm very sure that a lot of bloggers did not know that. Section 26 prohibits, now note that offenses under this act can only be tried at the Federal High Court. That's why Uturofon Morgan was taken to the Federal High Court. And some other people have been taken to the Federal High Court. The funny thing about Federal High Court is that the judges are not from here. So when you are crying in your language, the judge doesn't understand. He goes ahead to either convict and sentence you to terms of imprisonment or fine and imprisonment. So my brothers and sisters, be very mindful of this. those are the key sections I have seen in the Cybercrimes Act law of the Federation of Nigeria. There are other provisions, but they relate to a lot of other things. But these ones directly relate to what you do as journalists. Other related infractions, going by the topic. Aside from the Cybercrime Act, the Cybercrimes Act, there are other laws bordering on press infractions. A typical example is Section 382 of the Criminal Code, Laws of Akwa Ibom State 2000, which provides for criminal defamation of character and prohibits the publication of any material which is likely to injure the reputation of any person by exposing him to hatred, contempt, or ridicule, or likely to damage any person in his profession or trade by injuring his character. That's unquote. This section can be activated against anybody. And that is why the Honorable Commissioner, who is also a lawyer, did mention that when you defame someone, the person has an option, whether to take the criminal option or to take the civil option. Maybe if you defame a pastor, he will take the civil option. If you defame a politician, or if you defame me, I will take the two options. So that you can understand what the law says. So, this section of the Criminal Code law of Akwa Ibom State allows the police, and the police have prosecuted a lot of people on this, to take someone to court for criminal defamation of the character of a citizen of this country or criminal defamation of an institution and so on. So this calls for caution. Now, by Section 384 of the same law, any person who publishes any defamatory matter knowing it to be false is liable to imprisonment for 2 years. This one does not even have an option of fine. So you go in for it. 2 years is still a long time. We did a National Bar Conference in Owerri sometime in 2000 and either 13 or 14. And I lodged in a hotel that had 6 floors. And in the 6th floor, I wanted to take my bath, so I entered the bathroom and just jammed the door. I didn't know that the door of the bathroom was defective, so it locked me in. As I was the 6th floor, my phone, because I entered the bathroom, so I wasn't with my phone, so my phone was on the bed, no means of communication. I stayed for like 3 minutes, tried to figure out what I needed to do, and that was imprisonment for me. And it's not a funny kind of experience. So I had to now slide through the window, and I shouted. People did not even hear me immediately because that was the 6th floor. So someone then came and then rescued me. I was sweating. That was just for a few minutes. Now, 2 years imprisonment is not a child's play. If you have ever been to the prison, 2 years in prison, Nigerian prison, it's not child's play. So, but note that by Section 386 of the same law, the publication of defamatory matter is not an offense if the publication is, at the time it is made, for public benefit. Like during COVID, publication needed to be made for public benefit. So if somebody made a publication and then someone arrested him and said, why this and that, provided the publication was true, then this law will rescue you. And also, if the defamatory matter is true, I did say that truth is a complete defense in defamation. So publish what you want to publish, but be sure that it is true. If it is not true, you have cause to worry. Now, there is also the defamation law of Lagos State, which prohibits the publication of slanderous materials against persons and institutions. By Section 8 of the law, any publication which causes or is likely to cause serious harm to the reputation of another person shall constitute an offense. So it's not only here, even in Lagos. Now, if time permitted me to go into the laws of the various states of the Federation, you will see similar provisions. So this is something that is condemned nationwide. Defamation has been defined when you see page 7 of my work. I think it is important to read this for you. Quote, any written or printed article published of and concerning a person without lawful justification or excuse and tend to expose him to public contempt, scorn, obloquy, ridicule, shame, or disgrace, or intending to induce an evil opinion of him in the minds of right-thinking persons, or injuring him in his profession, occupation, or trade. The words used need not necessarily impute actual disgraceful conduct on the person. It is sufficient if they render him contemptible and ridiculous. You see some people say, this lecturer did this in the university, he collected bribe, whereas the gentleman has never collected bribe. He harasses female students in his class, whereas he hasn't done that. Once you do that and it is not true, it amounts to defamation. But note that, as stated earlier, the journalist is protected by law if his publication is anchored on truth and honest opinion. If the civil option is available, okay, I passed through that. So I didn't say that the journalist and blogger can indeed be guilty of the crime and thoughts of defamation. So you need to be careful. Now I go to recommendations and way forward. They're quite much, so maybe you read when you settle back at home. 1, let me start by thanking the Ministry of Information and Strategy, Akwa Ibom State, under the leadership of Comrade Inyemebong, himself a lawyer and a linguist, for deeming it necessary to organize this seminar with a view to blending journalism with law. I recommend that more of this should be organized. 2, the Nigerian Union of Journalists should deem it necessary to discuss with the leadership of the Nigerian Bar Association for possible synergy and regular interaction on issues of law. There are so many laws that you may not be aware of. 3, NUJ should do more to defend the interests of its members and should also do more to disassociate itself from persons who attempt to give the noble profession a bad name. NUJ should identify with its members who run into troubled waters in the course of the practice of their profession. What I mean here is for those that are being haunted. You know, you've interacted with them. They've told you that what they did is true. They've shown you the facts. And they're just being haunted. NUJ should stand up and defend its members. There's a story here. In 1985, when at that time Babangida was the military president. I hope you know Babangida is the only person, the only military man that called himself president. Others described themselves as head of state. But this one came with swag. I said, military president of Nigeria. And the question is, who elected you president? But that's for the past. Now, Babangida, Mama, and Vatsa were close friends. They grew up together. They attended the same school in Mina. And while Babangida went for training in India, Mama and Vatsa also went for military training in India. Now, they were so close that they were always seen together. But it just happened that Mama and Vatsa was arrested on the allegation that he was planning a coup against his friend, Babangida. He was tried, he was found guilty, convicted, sentenced to death by firing squad. Everybody was waiting to see whether Mama and Vatsa would be executed by Babangida. Close friends. I think one of them was the best man of the other. Mama and Vatsa's wife is from Cross River State, Sophia. She said that when Babangida, every time Babangida would travel abroad, she would bring the children and the wife to Mama and Vatsa's house for Mama and Vatsa to take care of the children. So that shows you how close they were. But they were convicted and awaiting execution by firing squad. Everybody was afraid to talk to Babangida. But 3 distinguished Nigerians, writers, Wole Inka, Chino Achebe, and John Pepe Clark, braved the odds and went to the Dam barracks to meet with Babangida. They interacted with him and said, Your Excellency, poet, and was also a writer. He said, this is one of us. We're sorry over everything that happened, but please spare his life and the lives of others. Well, they did their own. But when they left the Sudan barracks, they got the news that Mama Vasa was executed alongside others. But there's a lesson here. Yes, Mama was executed. But these people identified with their own in his moments of anguish. And that is what every journalist should do for any one of you that runs into trouble. Thank you. I've also said, number 4, that no profession can keep a good name if it has no mechanism for the sanctioning of erring members. In the Nigerian Bar Association, we have the disciplinary committee of the bar. We can take your certificates if you misbehave as a lawyer. The journalism profession should have the same thing. I understand your challenge. You know, how do you control these bloggers? How do you block the bloggers? Very difficult. But then, you can think outside the box and then have a way out to be able to provide sanction and to be able to also reward when need arises. Number 5, there should be training and retraining of journalists. Prof did say that they're talking about hate speech at the national level. A lot of people don't understand what it means. But here we are in Akwa Ibom. This has been organized by the Ministry of Information so that you can even know what to avoid. You cannot avoid what you don't know. And this is highly commendable. So this should be done over and over again. And this one is to journalists in government. Do not abandon, do not forget your friends that are not yet in government. Call for meetings for cross-fertilization of ideas and also sponsor seminars and conferences to serve as refresher courses for members of the profession. 7, journalists should be alive to their responsibilities in society. I have the feeling that Section 24 and other worrisome sections, which have been said to have negatively impacted the work of journalists, you know, and have put fear in some journalists and some bloggers, those that have fear, you know, if that section was thoroughly scrutinized, I'm sure perhaps been added or subtracted. But I use this opportunity to commend members of this profession for the beautiful work you did in the debate for the passage of the amended version of the Electoral Act. Your voices really mattered. And today, we have a number 8. Before you publish online, I suggest that you should apply this formula. This is the formula. Assuming I was working for an established and reputable media house with an editorial board, would the board have approved my article? If you are convinced that your article would have been approved, go ahead and publish it. If you are not so convinced, then apply caution and possibly edit your work and redo the story all over again. Go for more investigation, get more facts before you launch out to the public space. By Section 39 of the Constitution of the Federal Republic of Nigeria as amended, the right to freedom of expression and the press is guaranteed, and no one can take this away from you without an affront to the law. By subsection 2 of the same Section 39, it has been provided, I quote, every person for the dissemination of information, ideas, and opinions, unquote. It therefore goes without argument that the fundamental law of the land has got you covered as journalists and as bloggers. And no one can stop you from practicing your chosen profession without falling into trouble with the Constitution. However, in the same Constitution, Section 45, it has been stated that fundamental rights can be restricted and abridged, unquote, in the interest of defense, security, public safety, public order, public morality, or public health, or for the purpose of protecting the rights and freedoms of other persons. This is where the Cyber Crimes Act can rightly take legitimacy. And you cannot query that act. It is an existing law, and it can rightly be activated against anybody. 10, I admonish you to stick to the tenets of the journalism profession. Keep the streams of journalism pure and anchor your reportage on truth and veracity at all times. I'm sure if you do that, you will never run into trouble. It is those that don't do that that will continue to run into trouble, you know. And as we go into the election season, there is need for caution. Conclusion. When President Nixon, Richard Nixon, the 37th President of the United States of America in 1969, he never knew that he would leave office before the expiration of his tenure. The Watergate scandal pushed him out of office. Limelight by 2 days from Nixon, and showed clearly that the burgling of the office of the opposition party at the Watergate Plaza was authorized by the President of America. America could not accept that a sitting president would authorize such a thing on the American soil. On August 9, 1974, President Nixon resigned for fear of being impeached and handed over to Vice President Gerald Ford. Gentlemen, ladies and gentlemen, this unprecedented occurrence was exposed by members of the pain profession, your own profession. The pain profession is the fourth estate of the realm. It is the nightmare of dictators. It is the watchdog of society. But your work must at all times, the journalist and blogger must be ready and free journalism. While the journalist truly desires to operate in the freest of spaces available, society also expects that the practice of journalism must be done with the best interest of society at heart. They aim or have no business whatsoever being in this noble profession. Thank you very much, and God bless you.
Thank you very Thank you very much. Thank you very much. The chairman on the occasion, I think the keynote speaker has given us a very big gift, especially the journalists. And that's why the NUJ chairman is shaking and shaking and shaking hands with him. Because by tomorrow, our Akwa Ibom State Council of the NUJ will be celebrating the World Press Freedom Day. And there is no gift you would have given to journalists, practicing journalists, than what this erudite lawyer has just done. Thank you so very much. Mr. Chairman, sir, he didn't give this sort of, he didn't deliver this sort of paper in 2019. And he was appointed by the president of the Court of Appeal to be part of tribunal of the 2019 general election. I'm sure if they have listened to him also today, thank God next year is another election year. Sir, you also have another appointment. I say all that to say that the senior partner in the justice chamber has done justice to the topic he was given to do. Thank you so very much. Let me
I hope we enjoyed that moment where we had to unlearn a bit, and relearn some of the things that we needed to. If it is not too much, let's speak out one more time. And now, to further the discourse on cyber crimes and other related infractions, the legal implications, we'll be beginning the panel discussion. And that panel has been extended, and we have very wealthy and interesting additions. And so, without further ado, ladies and gentlemen, we'll be inviting our panelists to this very table. On this side, we'll be having the chairman of this occasion to also serve as a chairman in that panel. So let's give it up for the Dean, Faculty of Communication and Media Studies, Professor Peter Esu, to please come sit and chair the panel for us. Let's appreciate him as he comes forward. To also join that panel would be Dr. Nsikak Idiong, Head of the Department of Journalism, Faculty of Communication and Media Studies. Please join us on the panel too. And the Police Public Relations Officer, Mr. Odiko McDon, would join us on that panel. Ben King, please give us other members of the panel, please.
Thank you very much. While Mr. Odiko McDon is coming up here, let us also introduce 3 other persons who will make up the panelists. This other one, Destiny, told him something that he probably did not have known. Exactly 33 years after the death of Delegiwa, exactly on the 19th of October 2021, he won the award, Investigative Journalist Award of West Africa. Himself, the assistant managing editor of Premium Times, a lawyer, a journalist that when you see him, the story is written all over him. Distinguished ladies and gentlemen, I say all that to bring on stage here Mr. Cletus Upong. Welcome, sir. If this one has any infraction in the court, I think he is big enough to defend himself. You're welcome, sir. He is doing very, very well. Another person to join us here is thank you very much. I hope that is not cross-examination. The next person to join us here, I was looking at the time because somebody said something about her. I don't know whether she said it also of herself. They say she's a lawyer in the morning. She is a writer in the afternoon and an artist in the evening. And I was jittery. Would we still make it in the morning so that she can be a lawyer? But the good thing is that they say she is human at all times. Distinguished ladies and gentlemen, Enwongo Cleopas Akwa Esquire. Thank you very much. The last but not the least is a successful, sound lawyer himself, Clifford James. I think they say Clifford Thomas, I'm sorry, Clifford Thomas Esquire. With special interest in the Civil Liberties Organization. Successful lawyer. Thank you very much. The keynote speaker said 2 years is a long time. Please, sir, I didn't do that intentionally. You're welcome, sir. I think at this point, the chairman on the occasion himself also, the chairman of the panelists here, would decide on how best he feels the event could go this way. The chairman, sir.
Thank you. Distinguished colleagues, you know, I like using the word colleagues. We are comrades. This is our profession. I thank you for this session. This is purely another side of the interaction. I would please request that the keynote speaker, whose paper we want to discuss, should be here. Because during interaction, he will have things to say. So please, do kindly bring him up.
Very well.
And let him share the lady there so that she won't feel isolated by herself.
Absolutely.
Cletus, okay. You know, Cletus is a gentleman. That's why he's running away from me. Yes. Okay. While we are waiting, I should like to say this. We may not be the best of the experts in this, because this is zoomed around the world. But we are here to discuss the Nigerian issue in the global market. In most cases, when we're on this sort of thing, you'll find guys across the globe. Indians, East Africans, Americans, South Americans, and so on. Once the link is out there, they will join it, because this is a global issue. I was listening to that paper, and we have great men and a lady here who will discuss the paper. But I would like us to note a few things that I had listened to when we are carrying out this discussion on section 24. I had been worried about that section 24 because we have not put paid to the issue of faith. The interpretation of that section is not quite expatiative enough for them to pick. For instance, I was speaking about the same thing at a conference on this matter and COVID-19. And I had taken time to tell the world that when we say false information, which is an aspect of biased information, we must be able to identify the various levels. We have false information. It is not the same thing as misinformation. It is not the same thing as disinformation. It is not the same thing as underinformation. It is not the same thing as overinformation. And it's not this called information overload. So when we just, categorically make a statement like that, and we make a law, then there is a need to look at the law again. But for us, again, we must note this. And I'm sure that the various persons here will lead us on, because some of us don't even know some of these crimes. We've been told the implications, and the implications have covered certain areas. How vast has the Nigerian Act on cybercrime covered the rest of them? I had mentioned when I was speaking that we could categorize them into 4, but there are 10 different types of them. The laws we have they been able to cover that? Now we have with us here gentlemen who are either involved in the interpretation of the law and or prosecution processes, and we have gentlemen who are in the classroom who are also talking to others about this. Okay. And again, another thing is that we have been able to differentiate between the rule lines, the red line to which you will not cross and call this person a journalist. Okay. And we had also said that there is an opportunity. When our guest keynote speaker spoke about solutions to this and said we could think outside the box, I remember we said yes, we can think outside the box, and the simplest thing is by making the blogs, by going through the trainings, so that the news determinant will be taught them, the issue of objectivity and the rest of the things will be taught them. But however, we have the men to do the work, and we also have you to interact with us. And if we are on Zoom, if there is anyone out there who would want to interact with us, we would give opportunity for those people. But let me say that every interaction, the first set of interaction, the maximum time that it will be given will not exceed 5 minutes.
Very well, sir. Thank you very much, Mr. Chairman. So let's begin this panel conversation this way. In your different fields, what do you see as cybercrime? So we've defined it, but what are the examples? What have you, Mr. McDonald, seen to be cybercrimes and all of these that we're talking about? Mr. Chairman, please, you can begin.
Thank you. When we are restricted to the theme, whatever we want to do is on the theme. If you tell us to go outside the theme, you will bring us back again. For today's theme, we're looking at cybercrimes and other press-related infractions. Some of the keynote speaker did say that he would not take us in all. It would take hours. And then we have experts here who know the other infractions.
So let's just stay on the ones that are common in our client. What are these infractions? What are these crimes that are called cyber? Understand this professionally.
You are making a plea. You're making a plea, but you know this section, you have no business with it. Your work has stopped there. This section is ours, and as far as I'm the moderator, we will do it the academic way of doing things. So everything about compare is ruled out completely. So please permit me to rule you out, the compare, and ask you to please find a beautiful seat and sit down and watch. Because it is now these people versus these people. Once we finish with the session, we will pack our things and hand over to you, and then you will take up from there. Thank you very much. It is an academic exercise. Now, not that the issues you have raised are not in order. We will take them along. Not like this. We have listened to the presentation made by the keynote speaker. He had gone into certain aspects of the law, and he had talked about certain aspects of the penal code, and then he had also been able to bring up recommendations that could help us. In our midst, we have people. He actually said that in most cases, he is the one who writes the petition. That's why I said the man should not be left there. He writes the petition. He also goes to defend. And then he said the processes of prosecution rest on our friend McDonald. But we will not start like that. We would like to ask the head of the Department of Journalism to bring up his perspective on the presentation made by the keynote speaker, Dr. Nsikak Idiom. You have not more than, I'm the one timing. Once it is 5 minutes, I'll hit you. Sorry, and that's the end.
Except you are certified, thank you very much, sir, by the medical and dental body, council, as a medical doctor. So, a citizen journalist is not a journalist. He is an amateur. Having said that, I'd also like to go on and say that there is no press freedom without responsibility. Exists in this world with some level of responsibility. And I would like to join the keynote speaker in, advising our fellow journalists, especially in times like this, very circumspect in the things we write. When you come to study, journalism ethics, because laws can be made actually, but it seems to me that it is what the person knows in terms of right and wrong that will determine what the person does. What you feel is good. Immanuel Kant came up with what is called the categorical imperative. In other words, when you are doing something, ask yourself, would you like everybody to do the same thing under similar circumstances? And Aristotle also came up with the, with the principle of utilitarianism. That is, Aristotle's golden mean, that the best course of action is the middle ground between two extremes. The middle ground between two extremes. So maybe because you have some, some what might call some grounds against the governor or against any public official, therefore you go to press and write anything about them. Maybe because you've been commissioned, paid by somebody to do. Ask yourself, is that fair to that person? And so on and so forth. So for me, journalism should be practiced with some sense of responsibilities. And this is what we teach our students. It is not that we don't tell them these things, sir. We teach these things, but people choose to do what they want. Maybe for pecuniary reasons. Because they want to make money. Because somebody has, commissioned them to do those things. But these things, these practices or malpractices, as I'd like to call them, are injurious to society. After this administration, one administration has gone, after the person who might have commissioned you, might have paid you to write, that trash about somebody else, has left office, or he's no longer funding you, what next? How does that help society? The keynote speaker spoke about how children, how in the African society, in the African context, how children are groomed, are brought up. Is that what you want your children to grow up doing? Would you like another person's child or some other person to say the same thing to you? And so on and so forth. So, it's important, quite apart from the issue of prosecution or whatever, because those penalties exist, and those penalties should serve as a deterrent to people. But your sense of morality should also teach you, should also tell you, as well as the things you've learned in school, should also tell you that those things are not right. And which is why it is so important, and I need to stress this again, it's why it's so important for people who claim to be journalists to be actually schooled in the principles of journalism. And when you are schooled in the principles of journalism, you will know that there are certain things you just cannot do. That's all I have to say in that regard. Thank you.
I'll make friends here. I'll make a lot of friends, because once it is 5 minutes, I will stop you. This session by 2 o'clock at most will be done with it. There are processes when we're listening to the papers, because whatever we're taking on here will come from this paper that was presented. There are processes for prosecution, and there are issues in the processes of prosecution. And the best person to, in 5 minutes, discuss that aspect of that paper is no other person than our brother, McDonald. So he will take us on those processes based on the paper that was presented, and how we are either protected or can prepare or protect ourselves, and or what it is expected of us to, act on or behave, within the consequences of the entire processes that lead to litigation.
Thank you so much, Prof. The comrade Dr. Kman of Akwa Ibom government, my brother and friend Ini, thank you. And ladies and gentlemen, Council, you've done so well. I don't think what we are doing here is just, I think, an official. We're just nailing the, the coffin, just summarizing it. You have actually done a good job. Prof, I thank you, and I'd like to confine myself to the processes. First, let me start by saying that you need to answer the fundamental question: where lies the power to prosecute? Who should prosecute? And that is where we come in. That is where I come in. Section 4 of the Police Act has empowered the police to identify where there had been a criminal breach, to prosecute offenders, and we have also been empowered to prevent. So if we know that a journalist have done that where we are seated here, somebody was gathering articles. In fact, what he did, because when we went to investigate, as soon as I set the machinery in motion, we discovered that he had gathered certain fake articles and got some persons claim that some persons had signed a document saying that so and so person should not run for a particular office, that is not representing them. And those signatures were not true. And they had pushed it to a journalist. The thing was just at the verge of being published. And we got that information. We moved in at the computer point, that point of publishing, where they were doing their usual computer work, and then we were able to apprehend. So we can as well prevent the publication. We are empowered to do that. So it lies with us. The prosecutorial power lies with us. But then again, there's something we do. We try as much as possible to distinguish between whether the litigation process is civil or is criminal. Now, if it is civil, we have nothing to do with it. So I will have little to talk about, not because, as one who studied law, not because I do not know, but I like to, as much as possible. I wouldn't want to align myself with it. I'd like to run away from it and talk more about that has to do with my profession, which is, as it were, which is the criminal part of it. So where there had been a criminal breach, defamation, criminal defamation, we expect that such a person will make an official complaint. The processes, Prof said, such a person should be able to make an official complaint to the police via either coming to you walk up to a police station and right at the counter report the matter that, look, this is what so and so person has said about me at so and so time on so and so occasion. That will ignite either the person being invited or they go and effect an arrest. Such a person can as well, via an official complaint, what we call a petition. They know it. They are very good. These two people here, is your own that I've not been seeing so much. Maybe I've been seeing it without knowing. But these two people here, like those two people at the cross by Jesus, if you see the kind of petition that comes from these people, and they have a way of subtly passing it, by when they want to push their petition, that is when they call you, in fact, even if you're not a lawyer, you become their learned friend. My brother, my learned brother, brothers, bro, and that petition, you will push it and the thing will go through for them. When they go to court, they become tigers. This is what happens. You look at a lawyer and then when they start, is this not the Ekemini that I know? When it came to police, bros, you know, this just my client, I just want the commissioner to see it. I just want the commissioner to approve. When you reach court, now tiger don't become. So these are things that happen. So via an official complaint to the commissioner of police, we can look at the petition. The commissioner will have to approve it. And then one of the things I do, and the commissioner relies and ensures that I do most of those things, is that we try to sift it. We try to look at the part of it that is criminal and the part of it that is civil. And as I keep telling my colleagues, please remove your hand from civil matters. Even if but we have a way, of, you know, looking at it very well and analyzing it very well. Where we want to look at it very well, we can look at it very well and ensure that we can bring out the criminal part of it. So when that is done, of course, we can charge the matter to court. But then again, we try as much as possible to see if we can explore the options or the alternative of ADR. So we can, okay, now one, remain, Prof. Thank you very much. Prof, say 1 minute. So we can explore ADR, try to sort them, settle them. If they cannot resolve their issues, we can now charge the matter to court and allow them do their things, do their fighting. They can do a lot of fighting in court. But I don't know whether Prof will give me opportunity to talk again, but if I don't talk again, no problem. I've already spoken. Section 24. Journalists should not take Section 24 of this act for granted. It's a serious business. And when it is time, when it comes to time to that, if you have had anything to do with that, do you know what even some judges have passed through in terms of journalists? Politicians, everybody, most persons have passed. The journalists, in as much as they have been saviors, they have been saints, they have helped a lot of people. A lot of them too have been bones in the necks of some persons. So when you appear before some judges, after contravening Section 24 of this act, you will know that it's not business as usual. My submission is journalists should be wary and try as much as possible, as counsel has said, let your postulations or your positions be anchored on truth, and nothing but the truth.
Thank you. Thank you very much. I'm sure you heard when he said ADR. ADR. Did you note that? I'm sure you know what it means. Do we know the meaning? Alternative dispute resolution. We'll get there. But before then, I should like to move towards this side and ask Barrister Enwon Cleopas Okoa to lead us on this very issue of petition and defense. Because, you know, when you are discussing a keynote paper, you take the key issues in that paper and you dilute them, because the people seated there are going to interact with us very soon. Each of the questions may be directed at McDonald or Celsius or Idiom or Ewon or the keynote speaker. I'm the freest person here. You understand? I'm the freest person here. My own issue with the keynote speaker is that the paper is an academic paper, and in an academic paper that will stay in the archives, because it will leave here to our gas file, and I won't let it stay there because there's something I want us to do with this. And then it will leave here too, and it will get to the university. So avoiding to mention school is not criminal. It is Christian school in Lagos State. And for you to say it's some school in some state, in some this, the person who picks this document 10 years after will think that it's a huge joke, that nothing like that happened. And it cannot, in research, be pointed out. Having said that, Madam, how do we go about petitioning and defense? Because what people don't know is that journalists are also citizens. And they can also sue as they are sued. they can also sue. So in our own case as journalists, how do we go about, you know, this issue of writing petition? And how do we get defense? How do we defend ourselves?
Yeah, thank you very much, sir. I'm going to quickly add something to what my learned colleague had, earlier on stated in the paper about other infractions. So there is a part he had left out, libel, and there is another part he had left out, copyright infringement, which I have seen in recent times many journalists become liable for. So if, as a journalist, you pick, let's say, a photo that is not your own photo or wasn't taken by you, and you publish it without the permission or the consent of the originator of such photo, you could be held liable for a lot of copyright infringement, yes. And another thing he did also add to that was incitement and sedition. And as the political year is coming by, we are going to have a lot of that. And it's going to go beyond the Cyber Crimes Act. It's not going to be focused on the criminal code and the criminal laws that we have around us. So defamation and libel, slander goes together, and then incitement and sedition, and also the copyright infringement are some of the other press-related issues. But now to your question, sir. Thank you very much. One of the ways that you can write a petition, like I would always say, is to get the services of a lawyer. And this is not me self-advertising or advertising for any of us. A lawyer knows the law better than an average person out there, and he knows how to couch a petition on your behalf. He knows what section of the law to bring under, and he knows how to write the offense for which you want a petition to be written for. Now, when a petition is done and taken to the desk of the prosecutor, who is the police here, they are going to launch an investigation. They are going to get their fact findings, and if it's a case that is worth going to court, they will charge the person that you are petitioning to court. Now, this is where it gets very interesting. Defense. You would always need a lawyer. Now, the law allows you to defend yourself if you want to, but like I would say again, a lawyer would be the best person to defend a case for you. And the lawyers know where to, the books to open, and where to find to provide a very good defense. Truth is the number one defense, like he rightly has said. The other one is honest opinion. If at the time you published an article or a newspaper report or any form of writing, and you thought it to be correct, not necessarily true, but you thought it to be correct, and an opinion that is shared by a large group of people, then that could also form part of your defense for you. Now, if you took the article from somewhere else, you can also bring the other person that you've taken the report from, that you're going to bring him up as, a witness or an evidence. Yes, a witness in this instance. So you remove the liability from yourself, that I am not the one that is the originator of this article. I got it from so and so person. That could also be a defense. But in most times, the law would say that you have a duty of care to investigate what it is you are reporting. So we've seen a lot of times where we have mindless reportage. We have reportage without due investigations or finding out a certain thing. I'm going to give you an example. Last year, a young man, a very popular young man, published a NASCO conflicts story. I don't know if you remember it. That was led to trying to link NASCO to some terrorism, link here. And the same young man went ahead to publish a case that was about Inubon Omorin, the late Inubon Omorin. Now, while he was reporting in that particular article he wrote, he mentioned that a venue, or it's a hotel and an office in a wait housing, was a place where the conspiracy to kill and murder a newborn had taken place. But he had not done his investigations. And what happened? The organization in which he had wrote there took it up, and he got petitioned. But in this case, they did not pursue it to court. He had to offer a refraction and an apology. The newspaper for which he works for did an apology on his behalf. Sorry about that, my battery died. So when you're actually making a reportage like this, the defense that avails you are very limited in law, sadly. So truth and honest opinion. But if you can also link your source, you have an appropriate source for which you got your information from, that could also avail you as a defense, because that takes away the responsibility for you to be held liable to another person. Take, for instance, the young man that wrote something on Facebook and is currently being in prison for. If he can point out that he got his news story from a liable person
which he can bring out, and the person comes out to testify on that behalf, he can be set free, because then that is no longer going to be on him. Now, these are very tricky issues in law, but to be on the safer side, it's always good to investigate your story, get accurate sources, and your sources should be ones that are able to come out and defend you if you go to court. Because some sources will say, we are bound by privacy, we cannot come out, we cannot, come out and testify. And when that happens, you are left alone in the court of law with your lawyer trying to defend you. That will be my addition. Thank you very much.
And you kept to time. You kept to time. Thank you. I have been worried personally when that paper was presented about the issue of civility and criminality and the place of civil rights organizations and other movements in the making of these laws, in the amendment of these laws, and on the implications to the society out there. That when the keynote speaker spoke here, he said ignorance is not an excuse. And here we are. If Ministry of Information and Strategy of Akwa Ibom State Government had not organized this, some of us would not even know the meaning of phishing. Phishing, P-H-I-S-S-N-G, as a cyber crime. I did mention that there are 10 types of cyber crimes. How many people out there know? How many people out there were participants when this law was made? How were we organized to do, especially Section 24? I saw so many, I am a teacher of words. When you pick some of those words, they replicate others. Some should not even be mentioned. That it inconveniences me. At what level do you determine what inconveniences you? Thomas is not only a lawyer, he is a journalist, and he is a clawman. Over to you, sir.
Well, thank you very much, Prof. I was privileged to be under the tutelage of Professor Peter Isu. And it's really nice being taught by somebody like him, who is also a friend. I want to also thank the Commissioner for Information for being very strategic with his work. Even though he's a lawyer, but he acts less as a lawyer, but works more like a communications expert. I thank his team also. Let me start by speaking more like the activist I am. I may not be as academic as Prof had envisaged, so I'll be stepping on his toes on most of the things I'll be saying. To start with section, in fact, the Cybercrime Law Act is a copy that was imported from outside the country. Nigerian legislators have never been very original, because they have never taken the socio-political milieu of the environment into consideration. I agree with Prof on that part. Akwa Ibom is original. The Ministry of Information is trying to make Akwa Ibom original, even when the state copies a lot from outside. So we also thank you for giving some form of legitimacy to the illegitimate action of the Akwa Ibom state government. The problem of Section 24 is also cured by Section 24. Because if you read verbosely as what it says when you do it knowing. So when you do it without knowing, you have not committed an offense. I am a human rights lawyer. I'm a journalist. And I will be bringing all together. I pose some questions. What's the complexion of cybercrime in Nigeria as it relates to our socio-political and economic milieu, other than what we imported wholly, and we shamelessly say aptly, imported something that does not relate to us at all? The first question is, what is a computer? The cybercrime law did not define what a computer is succinctly to reflect what a computer is. Any form of electronic that assists you in achieving an objective is a computer. It only took section 382, 384 and 6 to define of the Akwa Ibom Criminal Procedural Act what the computer is. And I come back to us here. Who is a journalist? Was this cybercrime law made for journalists alone? No. It was made for everybody. And I dare say that we have about 65% of public communicationists parading themselves as journalists as not being journalists. Journalism requires training on the ethos, the ethics of journalism. Journalism requires training on the strategy of journalism. But is the NUJ a welfare of or a professional union? That question has not been answered. NUJ failed. Not in the states, because what happens at the national cascades down to the state. NUJ failed to define who a journalist is. NUJ failed to also regulate the profession as it should be. Why? Because he that establishes a newspaper or a medium of mass communication does so for the capital interest he makes, not to enhance or promote professional competences. So when you invest in any media organization, you are after money. You are not after promoting, as it were, the ethos of the profession. You are merely trying to make money. And he that pays the piper will dictate the tune. So if you, I remember there was a local paper here where the editor, and I think the associate, the weekend editor, they had finished the paper, laid the paper to rest. Unfortunately, the publisher went and published on the earpiece of that paper. It's a very well-known newspaper in this state. Published on the earpiece of that paper that the editor and the weekend editor have been sacked for stealing. In this state. Why? Because he owned the paper. He owned it for capitalism because he wanted to make profit, not to promote the ethos or the ethics of journalism. So he sacked his editor on the pages of the same paper prepared by the editor without the knowledge of the editor. I don't want to mention names here. But if you're reading the local papers very well, you know the paper I'm talking about. I've been informed that my time is almost spent, but I want to also take up the Commissioner for Information here. He had asserted, based on his knowledge, the problem of Nigeria is followership, and I dare disagree with him with reasons. The problem of Nigeria is leadership. The leaders of this country, the politicians of this country, like him, though he is not one of them, he is not, but he has fallen into that category of being a politician. Okay. I have just been corrected because I stand to be corrected that he's a professional in politics. It is the duty of government to create poverty and spread poverty and ensure that we all live on subsistence. The day you have enough food and good income, you will challenge the government and ask the government, how much did Akwa Ibom get last month from their location? And you begin to reason very, very reasonably. That way, the government does not like it. So the leadership that we are talking about here, which I said is a problem, they spread those who work for these papers to fight other people unreasonably without reasons. Indicated that I should not talk again. So I will refrain from talking, but will be very quick in saying that
I know Thomas will check the horn of the bull. The facing is 80% leadership and 20% followership. because leadership determines the kind of followers that we have. You know, because in selecting our leaders, the existing leaders make it difficult for us to be very expressive selecting our leaders. The selection process in Nigeria is very skewed, and the leaders determine who is taken to go to the section who leads. And so, that when you are in the midst of people who have control over power, they seek to determine the power next from them, not necessarily the people who want to influence it. Please, it is a quotation, not Peter Isu. Having said that, you know, the whole of this issue, I mean, is this problem of Cletus, so, you know, he has been fighting between and Chief Asam some time ago. So Cletus is a trained journalist, and he's working with one of the finest we train. Yes, we are a brand. When they mentioned Ray Epu, the late comrade Uno, these guys, you know, the first man to bring color newspaper to Nigeria, it's a man. These are Kwaibom sons. These are trained journalists. In that about crime, here it is a computerized device. The Honorable Commissioner spoke about the things to come. That is why I do not read new translations of the Bible. I read only King James Version original tongue. Not King James Version. King James Version original tongue. Because when you go to Revelation chapter, in other words, when you pick up another influencers video, I would deal with you. That's if you catch me in.
Thank you. Thank you. So, for the sake of time, there's a difference between truth and fact. And for instance, if you are somewhere and you see clearly that without you having evidence, you can't go right about that. There must be probably some record that you can present and have evidence this thing happened. You can't write about it. You've seen it happen, but can you write it? If you write it and they ask, or disrupt the business of journalism. Now, so I think we need to hold ourselves accountable for what, because we're very realistic here. I'm a professional journalist, and I need to offer some from what is happening in my own establishment. Most times, people use Premium Times as a reference point for quality reporting. But anyway, we have others like cable. There must be layers of checks. A reporter will file a story. I am an assistant managing editor and in charge of South and then Southeast. So every story from these two regions that must be published in Premium Times need to get approved. But then again is that we also have people for quality that even reject a story by me. So that is to have, meaning that the story publication step down. That's a lot of troubles. Some reporters think wrongly that when you do a story that is so negative, that is when you get the attention. No, it is wrong. When you are fair to the people concerned, including your readers, get the respect. Remember, I'm going to be very specific. Please, Prof, you permit me. I may take a little while. It's in court. I think 2015 election or during that tribunal era. And I saw property. That was, and I go back to the house and then did this. Now, are those that place? Show me the police here. Share. Those things very serious. Now, so we have layers of check. I find and it will look at. Or someone get it wrong with this story. I remember a case of someone who was arrested or claimed they said there was someone in Nigeria. And I called the person who had reported the matter, and the person said, look, I need to find out this, I need to talk with him. And I met him in the cell. I left there and updated the story that the man was in the cell, and we got the story. Now, we don't take these things for granted. Journalism has to do with integrity. There must be believability come back. But if you see here, oh, can this thing be true? Whenever anybody says, can this be true? That means there is a credibility question about our job as reporters and journalism. All right, so, let me quickly, Stanley, I don't know, some of these people like to say, sir, sorry, it was said in our WhatsApp group, there is no tape. And we said, what did he just say? He says that it was said in our WhatsApp group. Instead, where I said, no. We quickly called an emergency meeting. And we knew that there was a mistake. And we quickly brought down the story, apologized openly that we made a mistake. Come up. And should go to the extra length to call the media people, ask them, this thing, is it from you? There are a whole lot of things.
For you, with the Honorable Commissioner to please allow us to finish with this session. When they start this thing, internet, yes, all the one question must come from and must be directed at one person. Take them down, and they get to us so that you just take the questions.
Thank you. Blessing with other related infractions. And you talked about
in covering the. My name is Harris Nesian. In the last 6 years, I've been covering the court, and it has to do with till the end. Most of the time, from the initial arraignment.
So if you were there in the last event we had, you would have heard the university. What was the problem? It was a university prayer session that the university usually has, the solemn assembly. You would have heard the deputy version. Etiquette. You only adhere to them. I hope you understand.
Thank you, sir.
You can adhere to protocol. Don't stand on it. Thank you.
Thank you. My name is Ndonosian. I report judiciary and crime for Inside Newspapers. My question is directed to Odiko McDon on processes. Law is saying that the power to on the remand renewable.
I had said that you should just go straight and make a question there.
When you were speaking, you said that
told us that which didn't tell us the newspaper and the person involved in journalism, you must check your facts.